All right, good afternoon, everyone. Thank you for joining today's MSHA webinar series from Conn Maciel Carey. Today we'll be discussing successfully navigating MSHA complaint and accident investigations. Appreciate you all logging on. Welcome to those who are new, and welcome back to those of you who have joined our webinars in the past. Today I'll be your host. My name is Nick Scala. I am the chair of our National MSHA practice group here at Conn Maciel Carey. And we work with companies all over the country, whether operators or independent contractors serving the mining industry, navigating MSHA compliance, MSHA investigations, contesting citations, helping in the proactive aspects, and then also managing investigations with you all, whether that's through a complaint, an accident, discrimination claim from an employee, or an agent investigation. We serve to help you guys navigate all of those different instances. Personally, I've been doing this for about 15 years now on the legal side. Before that, I grew up in a family mining and construction business, worked through mining and heavy highway construction. And because of that experience there, I'm also a certified mine safety professional. So something that I've been in my entire life, definitely passionate about the industry and happy to continue to work with the industry now as an attorney representing them. So what are we going to talk about? I want to kick things off kind of by differentiating between, the types of MSHA investigations that we might see and how those differ from your rank and file inspections that we typically see. Then go through some strategies and best practices for managing complaint investigations and serious accident, while touching on some of the reporting and record keeping obligations that we have there. A lot of times when we get into these investigations, there's document demands, document requests from the agency. So evaluating what is expected of us and how we're responding to those, and some strategies and tips that we can take away and implement on the ground, hopefully just to be prepared for the eventuality or the potential that one of these may occur, but never having to run through that. So we'll start off just kind of looking at investigations. And, what I said before is differentiating here with MSHA. The way I look at it and the way I handle the enforcement, I differentiate between inspection and investigation, because I think the agency treats these differently and handles them differently, and the strategies and the policies that are followed by the investigators or the inspectors, they differ there. So when we say inspection, and especially for the purpose today, I'm going to be referring to, something like an EO1 is probably a term we know, right? A regular safety and health inspection from the agency. Or something like an impact inspection, where we're doing kind of a full inspection of the site. When we're talking about investigations, I usually mean something that's a bit more targeted from MSHA in what they're looking for and what they're trying to look into. So that could be, a complaint for safety or whistleblower reasons. Could be an accident or a fatality investigation, or it could be something like a agent liability investigation, where they're specifically drilling down into the knowledge of an individual with respect to a certain violation, or at least an alleged violation. So usually inspections, that covers the entirety of the mine, right? We're doing a regular safety and health, that's soup to nuts, record keeping, inspections, contractor inspections, kind of going over that entire area. And, it can include health monitoring. These are typically what we think of when we say the 2s and 4s, right? So if you're a surface mine, MSHA is going to be on site for 2 times a year, at least. If you're an underground operation, that's going to be at least 4 times a year. These regular safety and health inspections are what make up those mandatory 2 times a year or 4 times a year inspection for an operation. Now, sometimes these inspections form the basis for the additional visits by MSHA or an investigation by the agency. And we can see that when we're talking about, elevated enforcement actions being issued, or, some kind of event that leads to a special investigation to an agent. These are completed by what we'd call, like a rank and file inspector, or an authorized representative, as actually it's referred to, authorized representative of the secretary. These are the MSHA employees that come out and just do normal investigations. We're used to these, right? If we are a mine operator, we are comfortable, usually, maybe not comfortable, but we're at least understand that MSHA is going to come on site. They're going to do these inspections. This is what they're congressionally mandated to do by the Mine Act. And we know how those typically unfold, especially if we've been in the industry for a while. Now, one of the reasons I try to differentiate before this distinction between investigations and inspections at this in presentation and this discussion today is because unlike the world of OSHA or other industries where we don't have regular required inspections, in those circumstances, if a regulator shows up on site, it's a bit more of an all hands on deck because that's atypical. It's not necessarily a normal thing, and it's because there is maybe more reason for alarm. In the MSHA context, I find that sometimes we're too comfortable with the agency and too comfortable with the fact that they are going to come on site, they are going to do investigations or inspections, that we don't necessarily always distinguish and react appropriately when it isn't this regular safety and health inspection or this EO1 inspection type of visit. When it is maybe a whistleblower complaint or an agent complaint or an accident investigation, our strategy needs to be adjusted a bit. And we need to take into consideration the differences between, how the agency is going to respond and what their tactics might be versus how we need to respond. And, understanding that these are different, the commonality being someone from an MSHA with enforcement powers is going to come back out to the site and going to take a look at what we're doing and what's happening. That's kind of what we need to eliminate as the common ground, right? That is it. After that, we need to look closely at what the reason is. If it's a complaint investigation into a specific injury or a specific event or a specific hazard that's alleged at the site versus, going through a normal inspection, we have to, adjust it and recognize that because it's important for how we prepare ourselves for defense and also how we prepare ourselves to move through the investigation as a whole. When I'm talking about investigations, I mentioned a couple of them just as we were going through that last slide, but typically these are event driven in some way. You have a complaint for a safety and health condition. Maybe it's been called in by a miner. Maybe it's been called in by someone else about an unsafe condition at the site. Maybe operations without enough training, maybe operations without guards in place or lots of dust. Dust complaints obviously being a fairly common one of late. This will spur a different or visit from the agency. There's also the potential for these investigations to be related to whistleblower complaints or discrimination, retaliation, or interference with minor rights. And in those, it is a much different complaint. We're going to talk about that for an entire webinar here in April. It will have a whole webinar just aimed at handling MSHA whistleblower complaints. But that's much more of a almost employment matter than it is a safety and health matter. There's obviously significant interplay there, but the issues at hand are different. It could be an incident resulting from a serious injury or fatality event that took place on site, or following up on enforcement actions such as unwarrantable failures. Often that is a common cause or initiating event for an agent investigation that's going to look at the personal liability of someone in management on site. Now, sometimes these are conducted by, the same rank and file inspectors. Usually that's related to something on this complaint of safety and health conditions. Sometimes it's by a special investigator if we have whistleblower complaints or agent investigations. Or maybe just someone who has some additional training or experience or is from outside our field office area or even our district. In the event of serious injury or fatalities, you'll get people that have specific training on these kinds of investigations or what to look at when they're there. And they often don't come from the same area because they're trying to get a fresh set of eyes from the people that have potentially investigated that work site before. So all of these are things that if we hear these come out when MSHA comes on site, and they should be telling you why they're there, whether it's a regular inspection or for one of these investigations. We understand that context and we understand that there is a difference there. It allows us to prepare and react a bit differently. So we'll jump into that just by looking a bit deeper into complaint investigations. And, first off, I mentioned the safety and health complaints. And typically that's a complaint under Section 103G of the Mine Act. And it's in the event that there's a reasonable belief that an imminent danger or violation of a standard exists, and it's communicated to MSHA by a person that is a miner or a representative of a miner. Typically there's going to be some information about who it was. There'll be conversations between MSHA and that individual to get some additional context about what they're alleging. And then MSHA will come out to the site to perform some type of investigation. If we're someone who spent time before in the OSHA space, this is often something in that area that would get a letter issued to the employer that's a notice of alleged hazard or a NOAA letter, where we would be asked to perform some kind of investigation into it and respond back to OSHA with our findings, any corrective actions that we've implemented because of it, or if we have negative findings, that is the case. And then, after they review that, they deem whether or not they think they need to do an on-site investigation or they can close it out. With MSHA, they will come to site and investigate these. If it is made by someone who identifies as a miner or representative miners, the company should be provided with a copy of that complaint or a list of the complaints that are alleged. Sometimes this is, one item that is, a guard is not in place on a specific piece of equipment. Excuse me. Sometimes it's a laundry list of items that can range from anywhere as, inspections or maintenance is not being performed, or there's adverse conditions specifically somewhere in the operation. So once they go through this, they'll determine whether or not there are positive or negative findings, and if there's positive findings, meaning they found evidence of the condition, typically there will be enforcement issued. Now, as these are targeted, we should, try and identify what areas are being inspected or need to be inspected. We should try to help the investigator or the inspector get out to those as quickly as possible, provide the information that is necessary to help them investigate that. These aren't necessarily going to be kind of regular inspections. They can obviously turn into that if there are conditions observed outside of the complaint items, but usually we can look at what the complaints are, and especially if we've had a recent regular safety and health inspection, really dive into that with the inspector and target those areas to help move this along as efficiently as possible. But remember, MSHA has warrantless search authority, so they certainly have the authority to go out and investigate anything they see on the site. We don't have the ability to necessarily limit them like we might if we were, challenging OSHA's authority to come on site and went to the point of negotiating the scope or demanding a warrant for a specific scope. So things that we have to take into consideration. But if you are having a complaint investigation, I would most certainly say that one of the first things you need to do is ask for a copy of the complaint, the allegations. And as long as it's made by a miner or representative of miners, you won't be provided their name or information, but you should receive a list of complaints. Important that even if you know who possibly the person is, because of what is complained of in this in allegations, certainly, that is protected activity. That is about as black and white protected activity as you can have under the Mine Act, is notifying MSHA of what they believe is a hazardous condition. So definitely don't take adverse action against that person or take adverse action against the employee base as a whole. That is a pretty clear cut, not pretty clear cut, it is a clear cut violation of the Mine Act in terms of either interfering with the miners' rights or discriminating against them because of the exercise of protected activity, in this case, making a complaint to MSHA. So just take that information as it comes, work to move through the investigation, and then, remediating or correcting any condition that maybe is a positive finding. In the event that we have an investigation that comes from a non-miner or an anonymous complaint, and again, it comes through as an assertion of an imminent danger or violation, these we will not necessarily be provided a list of the allegations, which can be frustrating. we will likely just get a generic description of what MSHA is there to look at. Recently had a client go through one of these that was dust related, and all we knew was there was an allegation of unsafe dust levels at the site, which meant we walked through the entire site with the inspector while he made some determinations about the levels of dust that were present in different areas. We did not get a copy of the specific allegations, and again, that's because it was not communicated by someone that was a minor or minor reps. And eventually we went through a similar process in terms of enforcement and positive finding and going through remediation and litigation on that front. But just something you need to know about: if you're not being provided a list of the complaints, it's likely because this is why. It was not provided by a minor. It was an anonymous complaint from somebody else. So what happens when MSHA gets on site? Typically they're looked at and evaluated. If it is believed to be an imminent danger, again, that's something that means that the safety danger exists, and it may result in the death or imminent death or serious injury of a minor. Then they will immediately begin the investigation. They should immediately notify you of the imminent danger. An imminent danger is a shutdown until MSHA can see that the condition is stopped or the danger is prevented. One kind of item when we're considering imminent danger orders is the timing of being informed of the imminent danger order is very important for MSHA being able to sustain one. So that's to say, if a complaint is made that someone was working from heights without fall protection, and that complaint was made to MSHA, and the operator saw it or put a stop to it, or the person got down and was not working at an unsafe height, by the time MSHA got there to issue an imminent danger order verbally, then they shouldn't be issuing an imminent danger, because that danger no longer exists. It has been remediated without their involvement and without their issuance of the order. If one is issued in that situation, then obviously it should definitely be contested, because it's likely not a valid imminent danger order. The otherwise, if there's a serious alleged hazard or a violation, you conduct an inspection that is to begin as soon as possible. If there is a not serious hazard or a technical violation, then the inspector will either do it, maybe not with as much urgency, or when the next inspection takes place at the mine. We usually don't see these. If they are getting complaints, they're typically going to come out and look at those as quickly as possible, or it's determined that the violation doesn't exist or it's not within MSHA's authority. Then they won't come out and do an investigation at that point. So, that is a quick overview of just really where we see things go in terms of safety and health hazard complaints. Obviously, another area that we see this take place is whistleblower complaints, and I kind of touched on that earlier when I discussed, not taking adverse action against any employee who you think or can easily surmise made a complaint to MSHA. And this comes from the protections afforded to minors in the Mine Act, that no person shall discharge or in any manner discriminate against or cause to be discharged or cause discrimination against or otherwise interfere with the exercise of statutory rights of a minor or a minor's rep or an applicant for a minor. And really, that's meant to protect people from making complaints to MSHA, making complaints internally about safety and health conditions, and not going through and seeing those people disciplined or terminated in any way for engaging in that act. I'm not going to spend a ton of time on these because, as I mentioned, we're going to have a whole webinar dedicated to it in April. But I will just say that it's typically based off into a couple different areas, right? In MSHA, there is discrimination, meaning someone has had something done to them because of some action they allege that they conducted. So some protected activity they engaged in. Then there was an adverse action. And, so that could be someone making a complaint to MSHA and then being terminated. That's about, kind of as black and white as we can get. That would be something that would fall under a claim of discrimination. Another area that MSHA looks at and has the ability to enforce and investigate is interference, which would be something along the lines of you sitting down with all your miners and telling them, you know, if you were to report a complaint to MSHA, you would all be terminated, or one of you, whoever made it, would be terminated, because that would be seen as you interfering with the exercise of their rights. So whatever you did had a chilling effect on what they feel is the ability to exercise those rights. Now, obviously, I know those are pretty extreme circumstances and not the actions or behavior of normal and good operators. But those are just kind of trying to make some really bright line distinctions about what would be discrimination or interference. These programs get a lot of attention from the agency, especially over the last 4 years. They will be investigated by a special investigator. It will go through multiple levels of review. If MSHA believes it's warranted, they will, you know, file a complaint on behalf of the miner, or if the person has been discharged or in some way harmed, they could seek temporary reinstatement while the case moves forward. They move very quickly, so companies have to be prepared to move and react quickly to these types of complaints. That is very important. You need to be able to recognize, you know, as we've said before, between this kind of investigation and a normal inspection, but especially so in complaint discrimination. If your people don't, if sit on them for too long, you may lose your ability to really go through and be an active participant in it. So, you know, just an example there, the temporary reinstatement piece, if that is requested, MSHA will be tasked with completing their temporary reinstatement investigation within 15 days of the complaint coming in. So that gives you a bit of understanding that you can't sit on these. Your team needs to, you know, identify when one of these investigations might be coming in and appropriately ratchet it up the chain of command to either senior management or legal or outside counsel, whoever that might be, maybe and probably all of the above. So, you know, what I mentioned there, though, is just kind of the basics of it, though. You have someone who's in a protected class. So what we saw earlier on, that is someone who is a minor, an applicant minor, a minor's rep. They engage in a protected activity. Typically, in these cases, it's some kind of safety and health activity, right? For the purposes of MSHA, you know, alleged discrimination because of race or religion or gender or something like that is not protected by MSHA. You know, it has to be engaged in protected activity that is regulated by the agency. There's other avenues for such complaints based off other criteria that aren't safety related or safety and health related. There has to be some kind of adverse action, be it termination or reassignment or suspension or even just, you know, getting written up can be a basis for adverse action. And then a causal nexus between the two. You know, was the protected activity part of the reason why there was an adverse action? Those are all kinds of things that the analysis and the investigation looks into. These are going to be very interview heavy. MSHA is going to want to talk with, you know, rank and file employees. They're going to want to talk with managers. You know, there's going to be document requests. You need to treat this, though, like you are going through a very serious investigation, something along the lines of, you know, even an accident investigation, because the potential repercussions and the potential fallout, if it's not managed correctly, can be, you know, long-standing litigation, you know, the temporary reinstatement being ordered and issued. They can be difficult to handle and to navigate. So you have to be able to react appropriately when those come in. Another option on the investigation side is agent investigations, and these are Section 110 of the Mine Act, and I touched on these earlier as well, where, you know, MSHA has the authority to investigate individuals for civil, meaning a penalty, a fine, or criminal penalties, right? Now, criminal is certainly an option. MSHA has the ability to pursue criminal action in conjunction with the Department of Justice. They have done so and done so successfully in the past, but this is almost always in these successful prosecutions associated with fraud or falsification. Um, so, I don't want everyone to think that every time a D order is issued that they're going to be criminally prosecuted by MSHA. It's very rarely the case, but if there's instances of someone knowingly falsifying documents or intentionally, attempting to defraud the agency or lying to an investigator, these are certainly areas where MSHA can and has successfully, sought criminal penalties. One of the most recent examples is there was a coal mine that was falsifying their dust sampling records by having the pumps run on the surface in I believe it was a storage closet, and then submitting those results as being from the working face. So, that's kind of the level of things that we typically see that result in criminal. It's, very unusual and typically related to those kinds of activities. But the penalty side, the civil side, that can be associated with kind of any kind of enforcement action that is an elevated one. And usually we look at those as being unwarrantable failures are the most common triggering event. So an unwarrantable failure says that someone at the mine or the operator engaged in aggravated conduct constituting more than ordinary negligence. So in these circumstances, MSHA can and often does open up a follow-up investigation to see if maybe one particular manager knew or should have known of this condition given their responsibilities and failed to take appropriate action. And in that case, that can result, in additional fine being levied to that individual. They aren't as accelerated in their timing as whistleblower complaints, but still move quickly. You'll likely receive a notice that the investigation is taking place by a special investigator, along with the demand of documents or information or interview requests. They will focus heavily on interviews and a pretty robust review of the record. I know a lot of sometimes people want to take a stance that we aren't going to participate in that, which is obviously you're right. If you don't want to participate and be part of the interview process or be part of the document production, but one, MSHA can compel document production from the company. For the interview process, it's fully the right of each miner, which includes management, to be involved and be a participant in the interview process. If you're the subject maybe of a 110 investigation or a group of your managers maybe, I think you have to be measured in how you approach that, and hopefully you're working with legal counsel or those individuals are, so that they can have a good strategy specific to those factual events. But if you don't participate, you're letting MSHA build that narrative on their own without your involvement. And a lot of times, these are instances where we can head off maybe the finding of civil penalty into 110 by getting the right information in the investigator's hands. And if not getting it in the investigator's hands, going through the manager version of an informal and sitting down with the district manager and sorting it out. There are opportunities there before you get that penalty issued, and then you're in the contest process. But that is always an option too. The penalty gets issued to a manager, and then you have the ability, just like with any other MSHA citation, to contest it and litigate it within the framework of the FEMTRIC judges. Oftentimes, if you have 104Ds that are associated with this, hopefully you're putting those into contest. And you can often stay the litigation of the 110s until the agent case is at least on a parallel track with it, so that you're not having to litigate the same things multiple times. But again, being able to identify that this is a different investigation, that you're going to be dealing with a special investigator, that the tactics are going to be different as well as the demands, are important steps in moving these forward effectively. So at least on these kind of complaint investigations and the agent investigation, what are some takeaways? What do we want to do? We just want to make sure we train our employees on, especially management, on the discrimination or the interference provisions, know how to properly coordinate, how to respond and coordinate with legal, have a playbook about how we respond to complaints, whether those are internal or maybe some coming in from MSHA. Know that all your miners know their rights during an investigation, the right to participate and with MSHA, and also the right to refuse to if they don't feel comfortable doing so. To have that laid out. Recognize the differences between a normal inspection and an accident investigation or a complaint investigation. Understand that in the course of any inspection, but this is especially true investigations in complaints or discrimination or agents, that you could be held to the company being accountable or to even yourself in the case of an agent investigation. And even if they are not recorded with a tape recorder or something of that nature, it's going to be recorded in the inspector's notes or the investigator's notes. And always, I think, contact counsel, whether internal or external or senior management, as soon as you hear that a 105C, a discrimination complaint or interference complaint or an agent investigation begin, so that you can get ahead of those, especially with the short timing that are associated with them. So we'll dip into now what our incident, and I think put agent investigations here because I think these are some of the areas that we lead to agent investigations and how those transpire. One of the first things we have to look at is our reporting requirements to MSHA. And this is especially true for the purposes of accident events in particular, and understanding what is the immediate reporting notification requirements. If you're not familiar with that, it is when there is an accident, which we'll talk about here shortly, at a mine site. We have, as an operator, 15 minutes to contact MSHA after we become aware of it and management becomes aware of it. This includes independent contractors. So you're going to have to be prepared to make a quick decision if this is required. And also, if you're an operator with contractors on site, you need to make sure that you identify who's responsible for contacting the agency. That's a very important step that is often a stumbling block when we have an immediate reportable event that relates to a contractor injury. Is sometimes the contractor doesn't know they have to call MSHA, and the operator is expecting them to call MSHA. And then when the agency eventually finds out about this event, now they are going through and conducting their own analysis and who was responsible. And an operator can be either the independent contractor or the mine operator. But oftentimes, if there hasn't been some kind of established protocol there, and maybe the contractor did inform the mine operator, MSHA is going to hold the mine operator responsible for having to perform that notification. So something that I always tell people when we're talking about working with contractors on site, have this expectation laid out very clearly so that you know who is going to be contacting who. What is the phone tree? Is it that as the mine operator, you want to be the funnel for information to MSHA? That's fine, but the contractor needs to know so that they can contact you and then you contact the agency as soon as possible. This is a very quick window. It really, 15 minutes can happen in the blink of an eye, especially in an emergency situation. It's very different from the OSHA stance where we have 8 hours for your fatality or 24 hours for an inpatient hospitalization or an amputation. So 15 minutes is very quick. Everyone needs to be prepared for that. Each mine needs to have that kind of framework in place. The failure to call MSHA when you have a death at the mine or entrapment of an individual that has a reasonable potential to cause death can be $7,500 under the most recent iteration of the penalties at a minimum. That is a minimum. So we'll go up from there following the statutory max, so up to 90,000 potentially. But that is a minimum penalty on that citation. So there is a financial aspect to it as well. The 15-minute rule really came about, this immediate notification following several events in the early 2000s that MSHA wasn't notified in a timely fashion, and therefore mine rescue crews couldn't be mobilized, and it took hours and hours for people to get on site where there were miners trapped underground. Obviously, that's what the agency is trying to avoid with this rule. Its application to surface operations, specifically, I think is somewhat called into question given they don't have the same criteria and the same risks as maybe, large underground operations, especially, those are located in remote places where you have to mobilize mine rescue crews from multiple locations. But nonetheless, this is a rule that applies kind of industry wide. So MSHA says that you have to notify them if there's an accident that takes place at the mine. They go on to identify in their definitions of Part 50, 12 incidents that could be considered accidents for the purpose of this immediate reporting. I've had to combine some of the lines here just to fit it on the screen for us all, but they start off pretty broad with the death of an individual or an injury to an individual which has a reasonable potential to cause death, which is always one that has questions surrounding it, as how do we know it has a reasonable potential to cause death. MSHA's recommendation here is that you apply that kind of line of thought broadly. So if it is, an injury that could spiral, MSHA would like to see you have that provided to them, and provide notice to that. But it's really a question that we often don't know. I mean, I've had clients where an individual has been evaluated by EMTs on site. They canceled life flight, put him in a ambulance and drove him for hospital treatment. And then later, a head injury surfaced that they weren't aware about at the time and resulted in a fatality. And MSHA, issued a penalty because they said that you should have known about this at the time it occurred. Obviously, that's a quite situation where we relied on EMT's evaluation that the person was in good health, that they had a leg injury, but nothing else really was bringing alarm so much that they canceled the helicopter coming in to take them immediately. But those are questions. There's been a lot of litigation on what has a reasonable potential to cause death. MSHA is certainly trying to get that to be a broader and broader definition. Then there's some specific items in here that apply to underground operations. Again, this was really devised with large underground operations in place, but each one of you should be looking at this, see which one of them may apply, and have a good understanding of which one of these dirty dozen, so as they're called sometimes, may occur at your operations. Obviously, if you're not an underground operation, damage to hoisting equipment in a shaft or slope probably isn't something that you need to be aware of as an immediate notifying event. But if you are those kind of operations, you need to know that might apply. But usually we see this as the death of an individual or an entrapment or an injury which has a reasonable potential to cause death being the triggering event. When we trigger that, we have to call MSHA's hotline. This is often a source of frustration for companies, because you call this hotline, there are a list of questions. It is not manned by MSHA personnel. It is a call center. They will request some specific items such as the location, what is the reason for calling, giving person callback number, and then you will hear back from MSHA. Depending on when you hear back from MSHA, they will go through a number of different things. Likely they'll issue a 103J order, this assuming it is a serious accident or a fatality situation. Verbally, which will be an instruction to preserve the scene. They will immediately dispatch some investigators or inspectors to the mine locally. They will likely mobilize the closest inspectors. And then they will come, they will secure the site and remain there until an off-site or out of district or out of field office investigator team can arrive at the mine. If it is a fatality, this usually comes from either another district or a field office that does not share jurisdiction over that operation. If it is not a fatality, maybe it's an injury, this could result in, MSHA just asking for regular status updates on the individual. And, asking what you're doing in order to protect the scene or remediate conditions, and coordinating on rescue efforts if there are, those are ongoing. Oftentimes we've seen where MSHA, has asked, for continued updates on the individual. We have to do the best we can to provide these. I know there's often concerns about HIPAA protections, but as long as we can provide updates to MSHA, if someone's condition it's not fatal, but maybe they're undergoing surgery and MSHA's waiting to see how severe it is, we need to try and provide those. And if at some point the injured worker or their family no longer wants to provide us with updates and we don't have an option there, then we need to make MSHA aware of that and make sure they have the contact for that person, so that they can try and determine that. Because often that will determine, maybe the immediacy of their response and getting on site. And then finally, you could have a situation where MSHA orders all operations to halt at the mine until the agency gets there. That's not likely. Usually we have the ability, at least on the 103J and 103K orders, to give them a good description of where it occurred and avoid maybe a site-wide shutdown. But if you don't early and often have that discussion about what areas are affected or not affected, we expect MSHA to go with a pretty broad brush on those shutdown orders. In terms of kind of responding on site, what do we want to do? This is very high level, but it's important because oftentimes, we're working so quickly to try and take care of the injured individuals or correct a condition that we have to also make sure that these basics are starting to register with us, and we have someone who is at least thinking through what we have to do in order to preserve the scene and begin the investigation. Ideally, we're going to be able to rope or barricade the area where the incident occurred. Prevent access to or removal of any materials or equipment until, internally we review it, or if MSHA is coming on site to complete an investigation, that their investigation is completed. This is especially true if we have 103J or K orders being issued. At that point, if we remove items from the accident scene, we can receive additional enforcement on manipulating the scene or failing to preserve the scene. And often those incidents are innocent enough. Maybe someone didn't think about it. They just grabbed this equipment because, it wasn't necessary in there. But, often that just taints the rest of the investigation with this concern that maybe we were trying to affect the investigation after the point. So make sure that we're very clear in leaving everything as it is until we start to get permission to remove things and to change things. If there's activities that have to take place in that area where the accident occurred in order to further protect employees or prevent damage to the mine, we can act on that. I suggest if MSHA is involved at that point, that we're very transparent with them about what we're doing and why we're doing it. But if we have to preserve the mine, we are allowed to do that and to engage in those activities, especially if it's for the further protection of safety and health and the condition of the mine. But be transparent in there, take very good notes on the rationale, the reasoning, and what we are doing, so that if we ever are called into question, we can have those documents and that analysis put together pretty quickly. Make sure that everyone is aware of what's going on, especially if we're starting to transition in new shifts and have people coming around. And this can take place for days or weeks or months after an event takes place. We often see these 103K orders stay in place for months, especially in the event of a fatality on site, where MSHA holds on to them. Maybe they're limited to a very narrow area or piece of equipment, but nonetheless, the protection still applies over those. And then begin collecting information, taking photographs that immediately capture the scene. If there's external forces or factors such as weather, we want to make sure that we are noting those. Understanding that our photographs are likely to be discoverable by MSHA, and we'll likely have to provide those and be asked to provide those. But if we are simply gathering facts about the initial event, we still want to make sure we do that, especially if it is in the outdoors and maybe, weather effects, bad storms coming through could serve to damage or at least change the accident scene beyond our control. As I mentioned, we do have an actual requirement to preserve the scene and not alter the scene. That is 50.12, the preservation of evidence standard. So it's something that we do have to keep in mind, and we do have to work pretty continuously with MSHA there. If you have an accident, you have the agency coming on site to limit your or to conduct an investigation, be prepared to have a lot of discussions about the 103K order and the scope. They will go broad. You can narrow that down, and the sooner you have those conversations, maybe even that initial one can be narrowed down. But often when I'm on site with the client in the aftermath of a serious event, a lot of what we're doing is gathering information, beginning our own initial investigation, but also to start having serious conversations with the investigators on the scope of what's shut down. If you don't need to shut down the entire mine, it shouldn't be. Even if you don't plan on doing operations in the next day or the next week or weekend, whatever it might be, while you kind of regroup, modifying a K order isn't necessarily always a quick process. So you don't want to be kind of behind the eight ball. In my experience, usually in the immediate aftermath, um, companies are always, focused on the employees, focused on the investigation. But then, within a few days, we start feeling pressures maybe for load out of trucks, even though it's not related to where this accident occurred. And if we're not managing the 103K appropriately, that becomes something that we can't do. So beware of that. Try and get your limit down to as narrow an area possible. If there's things that you have to do in order to maintain the mine or eliminate further hazards, obviously you can do those things, but I would recommend that you're transparent with MSHA while doing them. The internal investigation is an essential element here, right? My reason I bring this up is we have to be prepared, though, that if we don't do these properly, if we don't take adequate precautions, they can be used as really a roadmap by the agency in terms of enforcement, especially in a MSHA serious accident or fatality investigation where it might go on and be pending for months on end, and they might be document requests over the course of those months. Um, you know, Materials we create can be used to our detriment. So unless you're doing these at the direction of counsel, um, they are likely discoverable by MSHA. I recommend when I work with clients that, we conduct that incident investigation and that I am an active part in that. And so that it is being done at the direction of counsel. The actions by your teammates are being done in my direction, and we can make that a privilege report as we go through it. Regardless if you're doing it with privilege or with not, recommendation is that you do it with privilege, working with an attorney. You should avoid jumping to conclusions or making assumptions in these or in the communications you have. Be careful with communication, right? Because communication can be also requested by the agency. I know we all are very used to text messaging, and it's a really easy way to communicate with each other. I recommend you have in-person meetings to the extent possible, phone calls, or keep communications in email form. It sounds like a big lift when you're just thinking about it, but believe me, that is better than having everyone to turn in their phones and all their text messages for the last year when we have to go through discovery with the agency. Focus on the facts rather than the opinions until it's absolutely necessary. Just because, again, making assumptions or maybe going out on a limb on something that could have been a cause, but we're not sure. Often that's not the way it is taken when it's reviewed later on. If you're taking written recollection from employees, obviously that's an important part, and we have to collect that information. But again, if you're not doing it at the direction of legal counsel and you're collecting these statements and you're having people write them and sign them, MSHA almost certainly will usually rely on these a great deal. And if they're signed, they almost look at them as a sworn statement. So, those are important. We got to begin collecting those recollections. My recommendation is, though, that that be done after you've engaged legal counsel and it's part of that privilege investigation, or else they will be a first request and something we'll have to provide to the agency. And even if you do collect them, then, if they are a written statement, that signature at the bottom often makes a big difference in how MSHA looks at them. So consider not having them signed in that respect. Again, though, that's a company decision, something that you should work with your senior management on, your internal legal counsel, your outside legal counsel. Those are important distinctions, though. In terms of legal counsel, I've talked a lot about it. I mean, obviously, our recommendation and what we think is the most protective is that you gauge outside legal counsel, but inside legal counsel is very good. Often, though, those claims are given a little bit less deference on privilege if they're challenged, because internal legal counsel could be seen as doing this as part of their normal service to the business as opposed to in their capacity as legal counsel. And this also applies if we're retaining experts. Really, ideally, we think that should be done through outside legal counsel in order to have that information and those analyses protected. Preparing for MSHA to come on site is equally important, right? We talked about what we think is going to happen once they get there, and how can we prepare for it? Well, if they're coming out on site to do an investigation and do an accident or a serious injury, we know their roadmap, right? We know the playbook because it's out there. It is part of MSHA's handbook series that are available to us on the website as part of their guidance materials. But, we've also seen it through just being involved in a number of these events. So first and foremost, what are we going to see? We're going to see a focus on records and interviews. And that's going to be management and non-management employees. These interviews can often be a source of frustration by employees at the site, especially those that might have been involved in the accident or worked closely with the person who was injured. And then for that reason, they can be frustrating to have to recount the events multiple times. We can try and manage that as much as possible. And obviously they have the ability and the right to participate or not participate, but just be prepared that there's going to be a lot of repeat efforts and that we're likely going to hear MSHA ask the same question slightly differently many times. And that's especially true if that eventually then leads to an agent investigation where, 6, 10, 18 months later, you're having to rehash the same thing. So there is some, frustration that builds at that point as well, and something that you need to be aware of and able to help manage. Also know that what documents they're going to begin to look at. I mean, it's going to be training for minors working, minor training, annual refresher training, task training, workplace exams for the area where the incident occurred. If it was on equipment, the pre-shift examinations on the equipment, site-specific training records for everybody, including and especially contractors and visitors. If it involved a contractor, that's especially so. And then also, a Part 50 audit and review. This is always going to happen after the fatality investigation concludes, but it could also be part of the review during it, just to make sure you have those Part 50 records, like 7001 forms in your 50.11 reports. You can always begin gathering these. If nothing else, it's helpful for our internal investigation to really just start squaring that away. And it also can help streamline from MSHA. But you should always be asking to get these records requests in writing as opposed to just taking notes. That's something we recommend. A lot of times MSHA is just asking for them off the bat, and if they're the required records, right, we're usually expected to turn those around pretty quickly. But if it's a very broad request, ask for it in writing, and then you can begin preparing it, making sure that there is nothing privileged or that should be withheld, and the appropriateness of providing that to them. In terms of the interviews, everyone should just be aware of their minors' rights, right? So all minors, management, non-management, have the ability to speak with inspectors at the initiation of MSHA or their own, speak alone with MSHA, or decline to speak with MSHA. MSHA doesn't have the right to demand a interview alone, one-on-one with a person. It is that person's right to have anyone they want present with them. MSHA usually won't like it if it's a member of management. But if that is truly what the minor wants, then that is who will be able to sit with them. They don't have the ability to say no at that point. They can't coerce someone to speak with them. They can't force someone to sign or write a statement. Um, just things to be aware of. But really, the minors hold the power in these situations. If you're a member of management, especially if you are retained and have counsel involved, obviously, our recommendation would be that you have legal counsel with you during any time you sit down and speak with MSHA. And if not legal counsel, you should definitely at least have a witness there to help take notes. Um, don't sign anything without looking at it and reading it, making sure it's 100% accurate for you. Um, I've seen some pretty startling, notes from MSHA taken during an interview that are hard to understand and hard to follow, but people were ready to sign them until we asked MSHA to read them back to us. So if you're signing something for the agency and at anything point in life, right, it just needs to be very accurate to what you were actually saying it meant to say. So what happens maybe when we see a request here where MSHA asks for documents that are not required to be maintained? This doesn't happen all too often. Usually they focus on the required documents, but in the event they're asking you to provide documents that you're not required to be maintained, you have to look at MSHA's ability to request that information. Now they don't have subpoena authority, but they do have some pretty strong powers under Section 103H of the Act in order to acquire the information that they need to complete their investigation. And if you don't provide it, they can issue enforcement for impeding the investigation. So often what I tell people is you need to look at the request, get it in writing, review it with your senior team and your legal counsel, and determine if you're going to refuse to produce something, what is your basis for that? And how far are you willing to go in defending that basis? And, oftentimes that has to be seen as the analysis that you go through. What is your reason for withholding the document? And, will MSHA prevail at some point in time later on if you go through the litigation on that front? But likely if the agency is requesting something and they know it exists and it's related to the topic, maybe it's mobile equipment maintenance records and we had a truck that went over a stockpile. Those are not necessarily required records, but likely something that we would have to produce in that situation because, in all likelihood, we wouldn't succeed on a challenge to it on under 103H. But each one of those needs to be individually evaluated in order for us to really know where we stand. Can MSHA require records that are maintained longer than required by regulation or not required to be retained at all? So maybe this comes in the form of workplace exams more than 12 months old, or pre-shift inspections after repairs are completed, or internal audit or assessments reports. They certainly can. And I think that this comes back to our last conversation about evaluating why they want it and how hard we want to fight them on providing it and what information that might be conveyed in there. Internal audit and assessment records, their MSHA does not have standing policy on self-auditing like we see from OSHA. So those are certainly documents that we see them request regularly. If you're doing those under privilege with outside counsel, you should not be providing them because they're illegal and privileged materials. But otherwise, if they're just internal records, it comes back to how hard you want to fight MSHA on that because they likely may have a basis for requesting them. So you want to talk through that with the investigator, see if there's required records that could be provided. Pre-shift forms and workplace exams, every company's got to make a decision about what required documents you want to keep. And how long you want to keep them outside the mandatory requirements of the agency. You should really make sure, though, that you have a document retention protocol and that you're adhering to it. Because if you keep workplace exams older than 12 months or pre-shift equipment inspection forms after, repairs are completed or for a long time, especially without noting what corrective actions were taken, those could obviously be used against you either by the regulator or by some other adverse party. MSHA doesn't have a statute of limitations, so they can issue enforcement actions for things that happened in the past. Usually, though, what we would see in this situation is that maybe past knowledge or of a pattern or a condition or something along those lines would be used by MSHA to justify issuing unwarrantable failure orders or a flagrant violation or designating something as high negligence or reckless disregard. Um, so really, it is important to analyze all these and make sure that we're being careful in our review of that information because while we might think they're pretty nonchalant, if MSHA goes through our records and sees that, maybe we had a history of a certain guard coming off during a certain activity and we didn't take something to correct that more at the root of the problem versus just simply reattaching it, and that eventually led to an injury, that could certainly be the basis for some enhanced abatement. In terms of, takeaways here, just, your team has to be prepared to quickly respond in the event of an accident or a serious injury. Knowing whether or not or how to do the evaluation on the 15-minute rule, or at least knowing who to get in contact there. Being prepared to, isolate the site, begin your own on-site investigation, initiating that with outside legal counsel and organizing your documents and preparing the scene, having that protocol in place or that policy in place and having your team trained on it, not just with maybe the lead person on site or your safety person who covers the site, but multiple levels of site management is a good thing so that you have built-in redundancies in the event that people are out of office. Our recommendation is always to have legal counsel involved when you're getting in these kinds of investigations with the agency. We think that engaging with outside counsel, like our team here at CMC, is a really good thing to do and a beneficial strategy early in the process. And the earlier, the better, because then we can help you mitigate and manage the process as you go through it. And we're not, coming in 6 months later or 12 months later trying to, sift through what the information has been provided and what we might have done differently. Pay attention to some of the things that come on these citations that you get from the agency as they might apply to abatement or termination requirements, or the scope, especially with 103Ks, and actively negotiate that as you go. And then definitely, you always got to maintain separate copies of any file that you provided the agency in investigation. Don't give them originals, give them copies, and keep all the materials that are related to the incident and the investigation separate, for purposes of the MSHA defense, and also in the case that there's civil litigation that derives from this. Because a lot of what we're talking about here with the accident and injuries, that can, go from MSHA involvement to being a case where we have, additional civil litigation that files and workers' comp and other kinds of lawsuits, especially when we're involved with contractors, that can have significant financial burdens involved. So, with that, I appreciate everyone joining us today. Make sure to join us for our next webinar next month. We'll talk a deep dive on the MSHA silica rule a month before it's scheduled to go into effect for the coal industry, and a month and a year before metal non-metal. So we'll dive into the status of that rule, what you need to know, and also where it stands in terms of litigation and challenges. As always, feel free to follow our blogs for updates on a number of different topics, whether it's employment law or OSHA law or California OSHA or MSHA. We keep you guys up to date through those as well. We're happy to announce that the firm as a general and the workplace safety and health, OSHA practices, we've once again been ranked as a top ranked firm for Chambers ranking. So we're very proud of that. Also, feel free to directly reach out to me by any means below. And I'm happy to talk about any events that come up. Hopefully you never have to go through any of these types of investigations, but it's better to be prepared in the event that you need to. But I appreciate everyone logging on today. Thank you very much. Everyone have a great and safe day.